Thanks, Rose, thank you very much. Good afternoon, everybody, and welcome to today's webinar, Association Continuity and Other COVID-19 Concerns. My name is Craig Vaughn. I'm the president of Castle Group. Castle Group specializes in providing management services to apartments, condos, and HOAs in the Florida and Texas markets. We partner with approximately 300 associations and now are 1,700 teammates strong. Quickly, as a point, just to note at the beginning, there was a couple of questions that you sent in when you registered regarding property management as an essential business, and I just did want to confirm that the governor has designated property management as an essential service. So again, thank you very much for joining us this afternoon. First, I'd like to also thank you for your leadership. I'm certain that when you signed up to be directors, you had no idea you were going to be making decisions in the middle of a pandemic. So thank you for your leadership. Thank you for your thirst for information. We have over 500 participants registered this afternoon. We received 300 advanced questions. We have taken some time to go over those questions and kind of group them into buckets, and we're going to try and address as many as we can today. You're continue to ask questions through the Q&A feature, which Rose pointed out earlier. We'll try and fit those into the discussion as we proceed, although we have a lot of information to cover this afternoon. You will receive a survey at the end of this webinar, including an offer to continue the dialogue at another time if there are additional questions that you didn't think got answered or you wanted some more depth on the things we talked about today. So we'd encourage you to complete that survey. And if there's enough interest, we will revisit these questions and have another webinar at a later time. Final thing I wanted to say is we acknowledge that you are volunteers and you are acting in that capacity as board members. You don't have to be experts, and Jeff and Michael will talk about that later. And in most cases, you're protected, by using the reasonable business judgment rule. So we'll talk about that later. But before I ask Michael and Jeff to introduce themselves, I will tell you that please understand that this is a dialogue. We're having a conversation this afternoon. You're going to get a bunch of information. You'll get some opinions. These are opinions of Michael, Jeff, and I. They're not to be construed as legal advice. If you think you need legal advice, we encourage you to reach out to your legal counsel or other professionals. So having said that, Michael, if you could start, let's hear about yourself and a little bit about the firm.
Hey, Craig. Thanks. I want to say hello to everybody. Appreciate the number of you who have reached out to join this webinar. Obviously, crazy times, and we appreciate the opportunity to be able to speak to you and share with you. I want to thank Craig and Rob and James and all of Castle for putting this together. Mike Bender with K. Bender Rembaum. You'll hear from one of my partners, Jeff, shortly. We are a full-service law firm that concentrates in the area of representation of community associations. So we are living this. I happen to live in a community myself, so it's personal as well as professional as I'm dealing with this. We have 19 attorneys working out of our 4 offices in Miami-Dade, Broward, Palm Beach, and Tampa. So we are statewide, and we are basically what we do is we represent community condominiums, HOAs, few cooperatives, few mobile homes sprinkled in there, in all aspects of representation of community associations. Believe it or not, even while this pandemic is going on, we remain available. We have clients who still are conducting certain business as usual, which I think is important, trying to normalize as much as possible what's going on. But obviously, today is about addressing COVID-19 and trying to give people as much information and guidance as we can. So with that, I'll pass to Jeff.
Wonderful. Thank you, Mike. Good morning, everybody. Or good afternoon, as the case may be. It is exciting watching the participant count creep up, which is a lovely feature I didn't know we had for this webinar. We're at 297 attendees, and the number keeps increasing, so we're very grateful for that. Personally, I've been practicing for just about 25 years. I've published over 250 articles on community association life, dealing with new legislation and new laws and how they are interpreted and how they can be used and how they affect our Florida's community associations. If you have not received Rembaum's Association Roundup, then you will be after today, so long as you registered with the proper email address, and we can add any board members you would like. We also publish, my other partner, Robert Kay, who's not with us today, also publishes Legal Morsels, another similar article in terms of its use and help to Florida's community associations. We have 8 board certified attorneys. Soon we'll have 9, so that's almost just about half of us are board certified in this body of law. And as Michael said, we represent Florida's community associations, well over 1,200 of them. We also represent developers on occasion and help take some of these communities out of the ground. Let's see. I don't want to take too much more time so we can jump into the substance of the matter, but I will share that I've been on the board for 7 years of my association, so I do get a unique perspective. You'd think I'd know better than to do that, but it does provide me a very unique perspective. Back to you, Craig. Craig.
Can you hear me? Sorry. Thank you very much. And I will say I am on your roundup list, and I do appreciate it. It's a Saturday morning read for me with coffee. And I had no idea you were that old. So I've learned 2 things already today. So I do appreciate that. Guys, we have lots of, yeah. We have 6 items on our agenda today. First and foremost is a discussion on the closing of amenities. Then we want to address what to do if you receive a confirmation that there's a positive test in your community. We want to talk about quarantine and the board's responsibility to enforce quarantines. We want to talk about guests and visitors, who should be allowed, who shouldn't, what the responsibilities are of the board and what their legal options are. Association continuity in terms of assessments, collections, and cash flow. And then finally, risk mitigation and management. So lots of stuff. I'm going to try and move us along as your host. And we're going to start with the closing of amenities. There are lots of questions on this topic, guys. From our standpoint, from Castle managed communities, almost everything at this point is locked down. But what I would ask Jeff, if you could, with respect to the requirement, the legal requirement to close amenities, you know, where do we stand?
There we go. I would ask during this presentation if the host, who is behind the control board, do not mute either Michael's or my microphone any further. We will mute and unmute ourselves as the presentation continues. The most important part of closing amenities is the following. While you did mention reasonable business judgment, and we encourage our clients to use reasonable business judgment, when you're closing the amenities, according to the orders, it must be based on the advice of licensed professionals or emergency management officials. So you absolutely want to be in consultation with the association's legal counsel for discussion and have record of that, even though you may not be having formal noticed board meetings. You're providing as much notice as you reasonably can under the circumstances. You still want to keep accurate records of the decisions made. So you would want to at least have a notation, the manager can make it, or a board member can make the notation that various board members, whoever they were, that were in attendance, who had the conversation with the attorney, the advice imparted from the attorney, and then the closing of amenities, so that in the unlikely but possible event that someone decides to sue because of the closing of amenities, at least you have the background information necessary to show you did it correctly.
Talk to me about, if you could just summarize again, Michael, can we have meetings? Should we have meetings? What platform? Do we have to have residents participate? Can you take us through that?
Board meeting, again, what we've talked about with our clients is if you have a regularly scheduled board meeting, but you have no specific actions to take, you don't have to have that board meeting. It's okay to cancel that meeting. If you do have business to conduct, including what we talked about is, addressing your policies regarding the amenities or any other actions. I mentioned I have clients who are moving forward with some, necessary construction related work outside primarily, or things of that nature. Then you can and should hold board meetings in the same way you would otherwise, except you're not doing them in person. Or at least you shouldn't be. You should be, for the most part, trying to do them without being in person. I will say I have a couple of communities that say they have very large clubhouses and they're opening these clubhouses and sitting people 6 or 10 feet apart. I'm not sure that's the best idea unless you know that owners are not going to show up. You can't keep owners from showing up if you are holding a meeting in that fashion. I think what you do, although if you're allowing owners to attend by conference call or by speakerphone or by Zoom or Skype or anything like that, then it's on your notices. You're notifying the location to be that call-in number, that link, and so owners are allowed to attend. They are allowed to participate. It's being able to monitor that in order to allow you to conduct business, which is the challenge. I'll let Jeff add to that.
Thank you. I was just reading through some of the questions that are coming in, and I want to say thank you to everybody who's out there who sent us comments regarding the broadcast. I believe we have them all fixed at this time, at least I hope so, and I hope that the audio is no longer choppy in any way. Apropos to this discussion, I received a question, and we have a meeting that is scheduled, but in speaking with the president, it will be canceled. He has not yet advised the attorney of its date, but we need the attorney to be present. How soon should this be done? And the emergency orders provide to us that when we're providing notice, when we're scheduling a meeting, when we're rescheduling, when we're canceling, that we just simply act as best we can under the actual circumstances as they present themselves to us. So if we have ability to post a notice, we should. If we have ability to send an email broadcast, we should. You want to adhere to as many normal notice provisions as you can. If you missed an annual meeting, for example, Judy just asked, are we required to hold that meeting? And yes, at some point you do need to have your annual meeting. You might be able to accomplish that annual meeting electronically through a platform such as Zoom, hopefully no technical issues for you if you choose to do that, or simply wait a few more weeks until we're through this. We are not in a situation that is going to last forever. Remember, we can begin to see the rainbow at the end of what we're all experiencing. So if you were to schedule a meeting, hopefully towards the end of May, for example, somewhere into June, I would like to think that society will be somewhat operational again by that time, and you wouldn't then have to reschedule again. Mike, is Craig able to unmute? Is he with us again, or is he no? I see his head shaking that he is not, so we'll continue along. Mike, one of the things that's interesting to me, and I've received a few questions, is when do these emergency orders actually expire? So I went through a few of them, and I just thought I would share with the listeners that the short-term rental orders dealing with rentals less than 30 days, they expire on April 30th. Now, all of this is very fluid. It is subject to change, but the rental orders will expire April 30th. The mortgage foreclosure, as you know, the lenders cannot foreclose at the present time, and residential evictions based on monetary reasons, if the tenant doesn't pay, they cannot be evicted right now. Those orders expire on May 17th. Restaurants and bars are due to begin to reopen on May 8th. You'll be glad to know elective surgery can be rescheduled effective on May 8th. The stay-at-home orders expire on April 30th. And my favorite is this is very important for all board members. Of all the dates I've mentioned, the one I'm about to mention is the one you need to know, because right now you're using emergency powers granted by the legislature for these types of situations, but they can only be used during during the state of emergency. It's the best way to describe it. The state of emergency is set to expire, to sunset, if you will, on May 8th. And also remember that when you're trying to decide what to do, and someone says the executive order, it doesn't say that, it doesn't matter. You do what you need to do to protect the occupants, to protect the building. The associations you can be more restrictive in the closing of amenities, in handling the COVID-19 situation, if the board, again, to go back to what Craig said, is exercising their reasonable business judgment. And remember, to close amenities, you need to act on the advice of a licensed professional. Mike?
Craig's back.
I think I'm back, guys. I hope. Can you hear me now?
We can.
Yes, sir.
Awesome. Listen, thank you for carrying on again. A question that I did read, Jeff and Michael, if you can address, is amenities are closed. The governor's basically said close all the amenities, and we're getting some questions around one-offs. Can two people go and play tennis? Can I go into the clubhouse to get a fob? Can we have limited use of the pool? What is your guidance for your clients on kind of exceptions to the rule that everything should be closed down?
Well,
What's the value of a light?
yeah, that's a good start. Craig, I think that, listen, we've had those questions, and obviously, listen, people we're for the most part, quote unquote, locked up, and they say, well, we're locked up here. We want to be able to utilize what little we have. To answer the question specifically, as far as creating exceptions, I think that it is a dangerous precedent. I think part of the issue that you have, if you are, first of all, how do you allow one and not another? I had one community that was saying, hey, we're going to have the library open, but we're going to only allow one person in at a time. And my question to them is, how do you monitor that? How do you ensure that you're cleaning up before and after? And if you're not able to control those things, then you have the risk. And that's what we're talking about. With all of this, we're talking about risk assessment. And let's also remember, we're talking about unprecedented times. Mm-hmm. So, I know that yesterday you guys had the webinar. I know we've talked about with our clients as well about insurance. And I think that's something we'll touch upon if we have time later, but we can bring it up throughout the conversation is, the issue becomes, what's your risk assessment? And Jeff started off with, hey, what's the value of a life? And if you want to extend that a little bit further is allowing these exceptions. What's the risk you face by allowing an exception if it leads to someone then claiming, hey, because you allowed that, it resulted in some kind of spread and I was infected or impacted? Now, of course, there's a lot of ifs to that. If someone was to bring a claim, if someone could prove the claim. But the fact is, if they bring the claim, you then have a situation where you're addressing it with possibly coverage or very likely not coverage. Mm-hmm. Okay? And so you have that situation. So I think, my opinion, and I think would you share this opinion, Jeff, is that you're better off uniform application of closing down these amenities in accordance, and you can support that with the opinion of your council as well as the orders from your county and state officials.
And I would add to that as well, Craig, because you have a really good question, two people playing tennis. But it's not just two people playing tennis. It's two people, then two people, then two people. And then one of them nature calls and they touch the handles in the restroom. They touch the door. They touch the gate. And God forbid they're a carrier of COVID-19. The next unsuspecting person to go play a match of tennis, oh, it's fine. It's only two people. Little did they know they just got infected. It's just not worth the risk right now.
It's a great point. It's the use of the amenity, not the amenity itself that's closed down. You can open the tennis courts, they're open, just don't use them because you increase the risk. Right. I would also say what we find a lot is it's the vocal minority that are rattling the cages, so to speak. Most people in the communities we manage understand that, the dire circumstances we're in, if you will. So they completely respect that.
Craig, I'd like to address Star's question. Do you recommend for an association to have a closed board meeting, or should meetings be held only electronically? And really, first, to have a closed board meeting, even during the state of emergency, there's only minimal reasons why you can have a closed board meeting. Attorney-client privilege, meeting with the attorney, for example, discussing personnel. But short of that, the meetings, to the extent possible, need to be held in the open. If, for whatever reason, there isn't enough technology in your community and the board needs to meet to make a decision, or they're on the phone to make a decision, which is probably what would occur, then you immediately would then take the next step of notifying the members of exactly what just occurred. We have to do the best we can under the circumstances as they are on the ground, and each community is just a little bit different than the other.
Right. I agree. And I think that comes leads nicely into the next topic, which is, by the way, we did have a couple of questions on when should we be reopening our amenities. And I think at this point, it's too early, right? We don't have any guidance from the state. We don't have any guidance from the federal government. So I think that would be a topic for a future date maybe, but I think at this point in time, it's too early to consider. I'm sure you would.
Well, it is, but I would add to that, Craig, that if in fact, for example, I'm just looking at the orders and when they begin to expire. And if restaurants and bars can reopen on May 8th, I think the logical question then is, why can't the tennis courts open on May 8th too? So we'll have to readdress that, I think, in the future, but keep that in mind.
Yeah, well, and Jeff earlier was giving the expiration dates, and one thing which is sort of obvious, but I want to say it just because everyone, as they have gone on, in a week or two, these things may be extended. So to answer the question being posed, when can we reopen, we don't know when these expiration dates are going to be official.
Right, fair enough. Okay, guys, let's move on to positive tests in your community. So for perspective, Castle's got 45 positive tests across all the communities we manage. So we're well versed in this topic. We have got a playbook together that we'd certainly make available to anybody they want. And it talks about, okay, I get that call from a resident, I have a positive test. In fact, we go back to, I've taken a test and I think I'm waiting for the results. That's what we call a presumed test. And for us, in Castle's world, that's when we get the attorney on the phone, we get the president on the phone, we get our regional leadership on the phone, we get the property manager on the phone who's boots on the ground, and we sit down and say, okay, let's have a plan. What is our plan? And that plan basically talks about largely communication. What do we communicate to the residents? What do we communicate to the vendors that might be there, our team that might be on site, all kinds of things. And our playbook has all of those templated letters. So again, for those of you who haven't seen that, you're welcome to have it. We'll give you an email address at the end, info@castlegroup.com, and we can send that to you. But what I would ask you guys, Jeff, does the association, when I hear as a board, do I have a duty to advise the community?
So it's an interesting question that we all have wrestled with, obviously, because we've been through this together. And clearly there is a need, I think there's a need, to notify the community of the existence of the virus inside the community itself. However, under no circumstances would I ever advise to provide the name of the infected person or the house address or unit number of the affected person unless that person has asked you specifically to do that. And just because, being a lawyer and wanting to cover all bases, I'd probably want such a request to be in writing from that person. I don't know why they would want the community to know that. I think it creates a bad stigma, but I do think it's important that individuals know they need to step up their game, and that's why we need to let the community know that the virus is in the community itself. Mike, you want to add into that?
Yeah, just to piggyback, and I agree, with everything. Basically, the way Jeff just expressed is basically the way I express it as well. The one thing I would add, though, I think that even if the owner, the individual who tested positive, consented, I still think I would advise that if they want to share that information, let them share it. I think that it's better because they may change their mind tomorrow. If they live in a unit, say, with 3 other people, and the other 3 people don't want to be quote unquote stigmatized by that, then I think it's best that you 100% what Jeff said, you advise the community, because the community, again, and this ties in a little bit with the obligations of the fiduciary duty of the board and the management team in protecting the community as a whole. You do advise, but you don't give more specifics than that. But you do emphasize that you are doing everything you can, and the guide that you guys put out, Castle puts out, goes through all this, so people should read it. But you emphasize the importance of that you let the individuals who have let you know, obviously, have done their part, and presumably they are self-quarantining, and you want to make sure you let the community know this. You don't want to set a panic, so you want to let the community know, listen, they are self-quarantining, we're doing everything we can. We remind you, owners, to do your best, social distance, use your, cleaning methods, wear the mask when you're outside your unit to be safer. Urge, encourage, not mandate necessarily, urge, encourage. And that's what I would say with regard to that.
I think that's great. So to answer a number of questions that came in, yes, you should communicate. No, you shouldn't communicate the name of the individual. We actually have adopted a presumptive yes, second, we've positive tested, and then we have a multiple positive tests in the community. We have several of those, and that kind of ends the dialogue, if you will, on communicating the circumstances we're in. we do have some questions around, well, should I advise when someone now tests negative, should I advise the community? And what guidance would you give your associations?
Well, on that, I think the reason I think it's important is, again, I think you're sending out a generic notification. If you're good, and the only reason you consider doing that is if these are, I guess it depends also on the community, you know, and Jeff pointed out a couple of times, and I'll say it more times too, case-by-case approaches. But I think in general nature, especially in a condominium-like setting, the fact that someone has it, it's likely known. They might have shared it with a few of their friends in the building and it's spread. People are aware. So now the individual who tested positive, who's self-quarantined, who's now negative and is okay, is seen outside their unit. Before, if you can preemptively let the community know, hey, you might see this person, they've tested clean, they're good, don't freak out. Obviously, the letter will be a little more tactful than that, but essentially that's the point.
Well, one of the things
I'd add to that as well that, sorry, Craig.
Go ahead.
Oh, okay. Apropos to this conversation, Judy has asked us, our association of single-family homes is split into segments or parcels. Should we indicate which parcel? That could be also said for a multi-condo association. Should we identify the building? No, I think you're doing a disservice because then first, you're coming closer to identifying the individual, which we don't advise. But secondly, you're almost creating a scenario where, whew, it's not in my building, it's in their building, so I don't have to be as careful. And that's just not the case at all.
Yeah, that's a great point. And that's kind of where we sit from a Castle standpoint is even the positive, we're not doing that communication unless, you know, the board is specifically or the attorney specifically advising us because it's a let your guard down problem.
Right.
And we certainly won't do that. And the other thing is, I think the reality is while we know someone is presumed, because they told us the likelihood of somebody else being positive is probably fairly significant. So we would echo that. One last question that did come up in this topic is HIPAA. Do we have any obligations as an association relative to HIPAA? I think it's a quick answer, which is no, but guys, can you confirm?
Well, typically associations are not considered covered entities under the HIPAA laws. They could inadvertently fall into it for one reason or another, but generally speaking, the answer is no.
Okay, well, thank you. Guys, let's move on because I think it's a natural pivot now to I'm in a community, I've tested positive, and I know I'm required to quarantine. What obligations, first of all, what's the current law with respect to quarantining, and lots of questions around what are my obligations as a board member / association to enforce that quarantine?
If you test positive or you're returning from these hotspots, I think the orders in place require you to self-quarantine for a minimum of 14 days. And I believe that's you and anybody that you've knowingly come in contact with. So if there's family, people you're living with, they should all be self-quarantined for 14 days. And that is what is encouraged. I will tell you that we have, as you might imagine, as Craig, as you pointed out, we have been informed of positive tests in several of our communities. And anyone who's listening who has tested positive, I appreciate the fact that you've stepped up and said, hey, we have, and we're doing this on our own. It's vital that anybody who tests positive or thinks that they might be positive does do this self-quarantining to help stop this so we can try to get back to a sense of normal, whatever that might be, as quickly as possible.
Exactly. And then the other day I had come up a situation where it was suspected the individual had the virus. And I'll get to the end of the story. It turns out the individual didn't, but the concern at the time was, hey, this person isn't self-quarantining. What are we going to do now? Right. And what you want to do in that situation clearly is you don't want to confront them face to face if you think they have the virus. So you want to stay away from them. You have to be smart about it. Pick up the phone, send them an email, tell them you're on the board, you are a board member, that this is happening, and find out the real story privately first. If it turns out they do have it and they're not listening, and some other questions have come up. This would apply as well. For example, someone's jumping over our fence to get to the pool. I think the same answer, well, the answer for the quarantine issue is you absolutely need to notify your attorney. You need to notify the county health department. and possibly the CDC. The health department will typically notify the police department. I do know of one situation where an association notified the police department directly about the COVID-19, and they said, we're not going just for that reason, which I thought was remarkable. But in any event, we want to take advantage of every opportunity to ensure people are doing the right thing. And sometimes as board members, we have to play the role of parent when the child doesn't want to do what they need to do, what is the right thing to do. You have to make sure that the board is protecting the residents and the association.
Right, and again, that's a good piggyback off of that, is the role as the parent. It's a good description as parent, although you got to figure that you're parenting adult children. Yeah. And in that regard, you are not, and as I have if my 21-year-old is listening, he'll appreciate this. You can guide, you can urge and encourage, but you can't force, and nor should you, obviously. You're not going to, barricade people in their unit. And so you have to, the questions are coming like, what responsibility do we have to enforce these standards, or how can we go about it? As Jeff mentioned, you reach out to the Department of Health. They're supposed to contact local police. Police are maybe going to come out, as Jeff just said, maybe they won't. But you encourage that and urge it. And that does, by the way, even if someone is doing that, you still don't name them in the community. You don't put their information out that they are doing this, that, or the other thing.
I would say in our cases, I've been so warmed by people's reaction. They are telling us as an association, they're calling their friends, they're letting them know, they're self-quarantining. So the response has been heartwarming, I think. So there are going to be exceptions always, but as a general rule, we're not seeing any of that type of stuff. In fact, one of the things we do, if we know of a confirmed case, one of our protocols is call the resident. Engage, can we help? Let us know if you need to go to the doctor, because there's protocols we need to put in place for cleaning. If you're leaving the building, you're getting in an elevator, all those types of things. So I think we're seeing
they might have an animal, a dog that needs walking.
Another great example. So we're encouraging dialogue. There's some stigma attached to it maybe, but could affect anybody. So we're seeing people reach out and advise and help out their neighbors more than not.
And again, and this goes without saying, there should be no stigma obviously attached to it. In fact, and Craig, I agree with you 100%. That's what I have seen. People coming forward and saying, hey, we're positive or possibly positive. We're going to self-quarantine, and being open to assistance and to allow them to not spread this. And that's the only way this is going to get passed, if everybody does this.
Agreed. Okay, guys. We had a ton of questions on guests and visitors, and it's been an interesting evolution as we've gone through the process here. If you recall, the original guidance we got was no more than 50 people in a meeting. Then we went to 10. Now we're locked in our homes. We used to limit guests on a very basic, like tell them to be careful. And now we're kind of checking temperatures. So there's been a whole evolution of this process. What I would ask first off is, what authority does the board actually have to limit guests and visitors? And then I want to move on to a more practical, what are the best practices in this regard? So first up, what is the board, what is their authority, and is there any extra authority in their emergency powers?
Go ahead, Jeff.
Sure. Can we limit who comes into our building is the general question. Can we limit who comes into our association? And I think we first have to draw a distinction between a homeowner association that is single family homes and has a guard gate versus a condominium building that is 40 stories high and has 400 units in it. They're two different situations. The more perplexing one, in my opinion, is the one dealing with the condominium. I think first and foremost, the board's duty is to protect the occupants of that building. So long as the advice is based from a licensed professional or emergency management personnel, then the board, according to the legislative grant of emergency powers, is well within its rights to dictate, if for lack of a better word, who can come in the building. Now, you wouldn't want to be so restrictive that somebody's healthcare aide can't get into the building. You might have a moratorium on construction work, but you might have a consequence to pay for that. If Joe owner is in contract with a contractor and all of a sudden the contractor can't perform this voluntary beautification of their unit, and now there's a lawsuit that happens, and 6 months from now, would the association find itself embroiled in that lawsuit? It might. But what's more important, being embroiled in a lawsuit or saving a life? However, that's not to say that if that same contractor needs access to the building because a plumbing line just broke, well, we need to get the plumbing line fixed right away. So there are different situations. I know of a situation, in fact, I was on the phone with somebody this morning on the way in for this conference discussing, and I was shocked to learn that it's business as usual in this particular condominium. There's been no restrictions whatsoever in terms of who can come in. So this morning I was advised that this individual was stuck in an elevator with about 15 contractors all going up to a unit to do some work. And I was astounded that that was happening. And I think that board could have real liability, I think, if the virus were to spread in that building for setting up the circumstance where that occurred.
Yeah, and the only thing that, again, just to summarize, is there has to be a reasonable connection between the current situation and the restriction that is being considered. And I do, again, reiterate to board members that when you're considering these restrictions, get with your counsel, with what you propose, draft of what you want to propose, get with your counsel, get some guidance, get a written opinion, and then do adopt these things at, through a properly, noticed board meeting. There is an opportunity to do a unanimous written resolution, something you can discuss with your legal counsel, which can be done sometimes in lieu of a board meeting. But there does need to be a reasonable connection between the current situation and the limitation and the restriction. Limited reasonable restrictions on non-essential guests, in my opinion, should be should be able to be, I think would be considered valid if subject to a legal challenge. And as Jeff mentioned again earlier, just with, again, he did a weighing situation, which is what we talk about. It's what we do as your counsel. It's important that we provide you the options and your risk benefit assessments so that you can make business decisions. And Craig, you started off the conversation, business judgment rule. In order for you to make reasonable business judgment, you need to be fully informed. You need to know what your options are. You need to know the good, the bad, the ugly, the risk assessment, the cost benefit analysis. And that's where your business advisors, your castle management team or other management company, management professional, or your insurance advisors come in, your accounting advisors, if it's financials, and your attorneys when you're talking about trying to decide whether and what you can restrict or should not restrict.
That's great guidance, guys. And I think where we're seeing from a practical standpoint, where associations have landed on this topic of guest visitors is, limiting non-essential visitors. Allowing the healthcare worker, not allowing the housekeeper, the nanny, in some cases family, but limiting the visitation to essential visitors, if you will. One quick question, which I think just needs to
Craig, if I can, I'm sorry, Craig, real quick. I just want to remind everyone, though, it is a case-by-case approach.
Sure.
I don't, you're trying to create these policies, and you do want to establish certain policies, but with some ability for the board or the management team to be able to be contacted by an individual who has a specific need. Because someone may say, hey, I have a family member coming in. That family member may be in some way at helping them as aid or caretaker. So you don't blanket things in that way.
I agree. I think that's a great point. And all of these policies are adopted in concert with the association's attorney. So we certainly
my recommendation, yeah, for
that program. A quick question, just more of a personal opinion for you guys on this topic is, we got a number of questions and we're seeing in the news people taking, specifically with respect to condos, we want to take the temperature of our guests coming in. Just a quick thought on that.
Well, again, Jeff may add to this, but also the first thing that comes to mind is, and we've talked about this, is taking the temperature. The fact that someone has no fever doesn't mean they don't have the virus. It's a false sense of security. There's potentially other, how are you taking that temperature? There's other potential issues with it. But I think that first and foremost, there is a false sense of security in doing that.
I agree. Jeff,
I
anything to add?
purchased a thermometer. It finally arrived 4 weeks later, and the type where you touch the forehead. That type of thermometer, no. I know we can make jokes about the other types of thermometers, but they would also
Right.
no. However, there is the device that you can point at someone's forehead, and it will do an accurate body read. And I agree with you, Mike, that sure, there can be this particular virus, you can be carrying it around and infecting people all day long and never get sick yourself. So it won't eliminate those people, but it certainly, if someone had a fever, it would maybe at least identify that particular aspect. But what if they have a fever and it's a regular cold or a regular flu and it's not COVID-19 and they're a unit owner? Aren't they allowed to get to their unit even if they have a fever? So there's all kinds of issues that arise. I don't think the association should put themselves in the position of trying to play doctor or nurse.
Agreed.
Ultimately, that's why I come down on this issue. So I'm not a fan of, at this juncture anyway, with the technology that we have presently, of trying to screen folks as they come in the door. And I think it also creates a very dangerous situation for the person who's holding the thermometer.
That's, I think, good guidance for our properties. Thank you. Let's move on to something more probably relevant to treasurers. And I know treasurers are taking deep breaths around how this is going to affect, from a financial standpoint, their cash flow and collections and the operations. So there's really three main questions here. The first is, what stimulus money is available to associations? The second is, what do we do relative to the collections of assessments? And the third is, from a cash flow standpoint, what options do I have to manage through this situation? I'd like to hit them one at a time, and I'll start if I can. Question one, what stimulus money is available to associations? So basically the stimulus money we're talking about, it comes through the CARES Act. And there are two types of loans for businesses which may apply. The first is the Paycheck Protection Program, known as the PPP program. It's all the rage for businesses these days. And unfortunately, what we know is that the associations don't qualify. Am I on the right page there, guys?
Yes, you most certainly are. In fact, for not all, not all, but 99% of all community associations or nonprofit organizations subject to Chapter 617 in Florida statutes, the only nonprofit that qualifies is the 501c3. There's also a veteran organization under 501c19, and under a different provision of the Small Business Act, tribal business concerns also qualify. Businesses that are subject to Code 72 for accommodations in food service, sole proprietors, independent contractors, and the self-employed. Associations are just not in the list.
Yeah, and I know that will come, that hurts us as associations. A couple of things I will say in that regard. Number one, those are the rules, and sometimes the SBA doesn't do a great job of applying their own rules. So we do have associations that are trying to apply. We haven't had anybody successful yet.
Right. But they should try, Craig. You're right on that.
Well, hold on one sec. We had a situation where a lender was asking for an opinion of counsel that they qualified for the PPP program. And there is no way, based on the very clear guidelines of the PPP program, that could be provided.
Yeah, I think, by the way, I know that client, ironically. But the other thing I would say with that is there are some representations you have to make during the application process that I'd want you to get some comfort from your attorney with if you're going to go down that road.
Right.
So, but having said that, we do have a couple associations that have their own payroll, which is important, that have applied, and we're kind of waiting to see. Nothing, we haven't learned anything yet, no approvals yet. I do know that the Community Association Institute is lobbying. Everybody expects the current funds to run out, and there'll be more funds available for the program.
Craig, the funds have run out. Okay. There are 1,035,086 loans that have been approved and are in process to be funded. There is no more money. And what we're seeing on the national news is that the Republicans and Democrats are not playing nicely together. And
well, we're not doing politics right now.
No, that's why I'm keeping my opinions to myself on that. Well, but in any event, there's desire for additional funding, but we're not seeing the additional funding happening anytime soon.
Well, Jeff, I think that's a good point. And I think if for associations to think that might be an option for them, I think it's not like the light.
Well, it
They
doesn't
already got
matter
a
now,
million
the
loans that
money's
aren't
out.
funded under whoever already qualifies without adding new
Right.
potential qualifiers.
Well, yeah,
Craig,
just before we jump off that point, I'm saying just before we jump off that point, Craig, I just, it does appear that associations don't qualify, and this under the SBA guidelines, as Jeff knows them very well, what was unclear, and this is where, I'm actively involved with the legislation through CAI. What is unclear is whether those SBA standard operating procedures flowed through under the PPP, because there were some other entities, organizations that don't typically qualify under SBA that are supposedly being considered for applications. So the not-for-profit association doesn't appear to qualify, and 100% what Jeff said, but we're trying to get that clarified. So hopefully, and Senator Rubio, who's our state senator, is leading that charge. And this is why CAI nationally, and certainly here in Florida, we have encouraged everyone to try to reach out and get clarification to allow those associations to, as long as they otherwise qualify, have employees, have those types of salary things, can get their funds. Hopefully by the time that gets clarified, they will have reached the agreement and funded this further. So I would encourage associations to consider still following up with their lenders, because you do first have to go through your own bank before, because other banks primarily are not considering non-clients at this point either.
So I guess we could, stand by and hope for more clarification would be.
Well, there's more bad news to share. The economic injury disaster loan emergency advance, that is up to $10,000 for temporary difficulties. No more applications are being accepted as per the SBA due to the funding issue. That's on the EIDL. I haven't seen a similar no new applications under the PPP.
That's good. So PPP kind of guys, don't count on that money for those who are participating. It may come, it's not coming fast, and it's not clear. So those are, from an accounting standpoint, and I'm a CPA, those don't fit very well in my boxes. But we'll learn more as time passes. The EIDL loans EIDL loans is another option. Jeff just talked about the $10,000 kind of instant lotto win for a grant. The money's gone. The EIDL loans are still available. They are, I think the application deadline is December 31st. They're really not going to solve your short-term problem. And let's get to that short-term problem if I can. And it really speaks to question number 2. What do I do relative to the collection of assessments? Because I think, from our standpoint, kind of business as usual, for some context, we ran our global AR across all the associations we manage at April 14th and January 14th, the last similar quarterly cycle. And the numbers were almost identical, less than 1% increase. So that bodes well for the next short term anyway.
Right.
But we're recommending, kind of business as usual. I think for everybody out there, you don't have a problem with respect to your association operations if you collect your maintenance. So this is really all about collecting your maintenance. Guys, what is your position on kind of business as usual collections? What are we doing?
Well, that's the opinion I think that we also put forth, Craig. As board members, again, self-evident, but you have a fiduciary duty to undertake, your reasonable action to benefit the interests of the corporation, the not-for-profit corporation, the association, to ensure it can meet its financial obligations. You don't know these financial obligations, which, without exclusion, including but not limited to, as you say, you have insurance payments that are coming due. You might have internet or Comcast bulk communications, maintenance, and things of that nature. Those bills which are essential to the community need to continue to be paid. And so we do recommend business as usual with regard to collecting maintenance payments. But at the same time, I think it's important, and we have expressed this to our clients, to demonstrate some compassion during this period of unknown and uncertainty, and boards have the authority to consider hardships as they always have on a case-by-case basis. So if you have an owner who's requesting an extension or some sort of accommodation on payments because they're saying, hey, I've been furloughed or laid off, first of all, I think it's okay to ask them to document that, to provide documentation. But then boards should consider, again, we go back to the case-by-case approach, consider and work with your membership to work out what type of funds can be paid at that time to ensure the continuity of the association. I think that's really important. We do not recommend doing a blanket policy to forgive assessments, of course. I don't think you should be blanket waiving late fees either. That just encourages people who might not otherwise pay late to pay late. And Craig, as you mentioned, in order for the association to function, the finances need to be coming in. So I think it's important, business as usual, but with a more of a eye toward compassion when individuals are reaching out. And those of you who are listening and you're in communities, it is your obligation to reach out to your board, to your management, if you have a financial issue, and work something out in advance before it gets too far down the road. Keep in mind also, people are paying monthly or quarterly. If someone is 1 month behind,
yep,
that's something that you can work out an easier payment plan. When things go 3, 4, 5, 6 months, it becomes perhaps a bit more overwhelming to the individual, not to mention potentially financially damaging to the association. So do work out and encourage your membership to reach out if they have an issue.
Jeff?
And I want to address as well, piggyback a little bit on that, that some questions came up while we were doing this presentation, and I've been trying to answer them as many as I could during the time we are together. Couple viewers have asked, we can't use our amenities. Why should we have to pay our assessments? And I just want to make clear to everybody who is listening, the fact that you might have a beef with your association, the fact that you might be precluded from using the amenities for a period of time, the court cases are very, very clear. You cannot withhold your assessment payments as a form of protest. The association still has all of its lien and foreclosure options available to it in the event of an owner's non-payment. And I completely agree with Michael that these incidents have to be handled on a case-by-case basis when an owner can't pay their assessments for one reason or another. It should not be a blanket policy. Also, use this time before June 1st, the beginning of our next possible crisis, because that's the first day of hurricane season. If you haven't already, you need to arrange for some type of bridge loan where you have the ability to get your hand on necessary funds before the need actually arises.
Jeff, let me address that, because I think it logically flows into the next question, is though, like from a cash flow standpoint, what options do I have if I think I may have an issue? So to walk you through kind of a process as a treasurer, first take a deep breath. You're not there yet. You have maybe a little bit of time. It does not appear that there's going to be real government funds available to solve this problem in the time we need it. We advocate, what I would say to the treasurers, take stock of where you are, right? We advocate associations have 1 to 3 months of cash, right? The ability to pay 3 months of operating expenses before you have a particular problem. So look first to your surplus, what you have. I would say next, do I have an existing line of credit? If I do I draw it? There's some worry out there that even though you may have a facility, the funds get drawn, you might want to put the money in your bank rather than have a chance that the facility gets taken away. I'm not a big proponent of that. I think that, the banks are going to be kept fairly liquid, but that's just a personal opinion. The second thing I would say, or the next thing I would say, guys, and this is more to you, I have reserve funds. Can I use them? And I know there's different rules for HOAs and condos, but I'd like you to comment on that. How do I use them? How do I get access to them? Sorry, can I? How do I have to pay them back? Those would be my 3 questions on the reserve side. And just for the participants, we're going to run a little bit longer because we had that little hitch at the beginning. So we're going to probably run about 10 minutes late, or 10 minutes longer than the hour. So appreciate you sticking with us. But guys, with respect to reserves, what do I do?
Craig, while there are people still here, also we're getting some questions. How can I view this later? I want other board members to see this presentation. They're not online. Does Castle have a way for this to be viewed later? If so, what is it?
We do, and if you go to www.castlegroup.com, you can see the webinars will be posted. I think it takes a day or so, but the entire presentation will be there.
And the KBR website, we can put a link on our website as well.
Yes, you should.
For people to see that.
Absolutely.
Absolutely.
To your question, though, Craig, first on the reserves. Let's be clear first. The emergency powers, which are currently in play, do not change the Florida statutes requirements with regard to use of reserve funds. You pointed out HOAs and condos. I'm going to speak first on condos, okay? Condominium and even the cooperatives have statutory guidelines when it comes to reserves. So if you are funding properly funded reserves, those reserve funds are only able to be used for the purpose for which they've been designated under statute. The emergency powers don't allow you to dip into those reserve funds without getting the approval of your membership. And the approval is a majority of your quorum. If you're interested in using reserve funds, get with your legal counsel, get a written opinion as to exactly what you can do, how you can do it. But I can tell you in general, with a condo or co-op, you need the majority of the quorum to be able to tap into reserve funds for purposes other than for what they've been designated. HOAs are different. HOAs do not have statutory reserves automatically. You have statutory reserves if the developer created them at the time of the project, or the membership voted reserves in. Most HOAs we work with, and you could probably confirm this, Craig, is they don't have statutory reserves. And what that means is, even though an HOA budget might list something as reserves, if it's not statutory, that means it's really more like a contingency fund, which is subject to the board's discretion to use for proper association purposes only, and that would be governed by the association's governing documents. So with regard to reserve funds, that's the way they should be used. You should not borrow reserve funds with the intent of paying them back, and I'll tell you why. Borrowing without a membership vote could subject you to a complaint by an owner who's not happy with the board, and maybe no one has that, I know, who's listening, but in the rare instance of a member or someone not happy with how the board works, if they complain to the state and the state investigates and the state determines that you borrowed, in the past, I will tell you, my experience, if that was the case and you were paying it back, smack on the hand, don't do it again. DBPR has changed their policies, and we've seen it implemented recently on more than one occasion. There is no more slap on the hand, don't do it again. Now, will they change that because of the pandemic? I don't know. But they will. But what happens now is, instead of the slap on the wrist, they are issuing a violation, and they're fining the associations minimum of $500. So your better bet is to play it safe, get a vote of the membership. If the alternative is we're going to have to issue some kind of special assessment to the membership, most members will say, hey, use the funds that are there.
Right.
How you'd get that vote, obviously, you can do it electronically. You're not going to, you can basically do that by way of calling an electronic meeting. You can email out these limited proxies. Again, get with counsel, make sure they're done properly. But I would encourage that not to borrow the reserve funds with the intent of paying them back.
Excellent. Jeff, let me ask you a question, because you asked about, you mentioned emergency lines of credit and being prepared. We're working with a number of our associations to do just that, and a number of our banking partners, and they're all open for business, which is great news. But are there any restrictions on borrowing money from an association standpoint, and where should they look for guidance?
Well, during a state of emergency is different than not a state of emergency. So the board has tremendous powers to enter into loans and such as directly related to the state of emergency during this time. During normal times, we need to make sure that the board itself has the power to enter into the loan in the first place. Is a vote of the community needed? Are there certain dollar amount thresholds that are going to limit what the board can do without a vote of the membership? Is the loan purely for a line of credit for an emergency? Is the loan for a voluntary, we want to build a gazebo, which is different than, hey, our foundation is in jeopardy of collapsing. So there's lots of different mechanisms, but know that if you find yourselves in a situation where there's a real need to protect life, to protect property, then you need to reach out to your association's attorney, because notwithstanding the requirements that are set out in the governing documents, without going into a lot of detail because of time, there is a line of cases that allow an attorney to author a very lengthy legal opinion that provides, hey, in plain English, the board's got to do what the board's got to do to protect the property. You have police powers, and I don't mean woo, woo, woo. I'm talking about constitutional police powers, life, health, safety, welfare powers.
Excellent. Well, I think what I would recommend to associations out there who maybe don't have the expertise, talk to your property management company, talk to your property manager, talk to your professionals. I'm doing a lot of 10-minute calls, just check-ins on, let's look at your balance sheet. Let's see where you are. Do you have a problem or not? So I highly recommend you reach out and have a discussion with somebody. Guys, let's move on to the last topic.
Greg, just one real last point that I want to just make, and it's again self-evident, but if there are items in your budget that are discretionary, I mentioned earlier there are certain items that aren't discretionary and you need to be paying those, but there might be some items that are discretionary. There are vendors that are non-essential services. Maybe they'd be willing to work with the association on either temporarily suspending services or deferring payment. And that might be another way to help communities out on the budget side. And so definitely speak with your management team and figure out if there is that opportunity as well. Excellent.
Guys, last topic, and I think it's certainly relevant to all of the directors that are on the line, and that's the kind of risk that this environment is creating for me. As we talked about earlier, board members are volunteers. So talk to me first, guys, about the whole business judgment rule and how that protects me. And then as a follow-up to that, I'd like you guys to address, okay, what I should be doing now to mitigate my risk, because I'm going to get sued by the person who wanted to play tennis and couldn't, who wanted to swim because they needed to. So
hey, Craig,
talk about the regional business rule.
Craig, I have a question for you. Let's go back just to that last little example, because I know we have boards that are concerned about being sued because they closed the pool, because they closed the tennis court. And as Mike and I were talking about, and he so eloquently explained, what is their damage, right, Mike?
Well, right, it's the risk assessment. We did intersperse throughout this whole conversation these two topics, so I think it's important we can summarize. So I think I do understand you volunteers who stepped up to help run their communities. This is, of prime importance today, but it is a risk assessment. And, I think that if I tell you you can't play tennis for a couple of weeks and you want to bring some kind of legal action against the association, understand, board members, you're not going to be hit personally for this. Most documents have language in their articles or bylaws have language in there that indemnifies you as directors. As long as you're doing what you're doing and your decisions you're making are on behalf of the best interest of the community as opposed to self-interest or any of those other exceptions, like the criminal acts that and none of that applies here. So business judgment and the business judgment rule essentially is, so long as you're using reasonable business judgment, what it should be is a judge is not going to impose their opinion, their judgment, just because it might differ from what you as board members decided. And the best way you can protect yourselves in that regard is to reach out to your experts. Reach out to your association counsel, reach out to your insurance agents, reach out to your financial advisors, get written opinions to support the decisions that you're making or that the decisions you're considering, so that when you sit down at that quote unquote table to make that business decision, it's a fully informed business decision, reasonable business judgment has been followed. My understanding especially is if someone was to complain that you did something that they felt was not reasonable and you relied upon the advice of your experts, your attorney, for example, then you are best protected under the business judgment rule.
Good. Jeffrey, talk to us about insurance, and what should your considerations be from an insurance standpoint?
From an insurance standpoint, have as much coverage for as many different unforeseen events as humanly possible. Right. That's what you do when it comes to insurance. There's going to be a lot of claims. I would imagine that there's a lot of exclusions in a lot of associations' policies for what we're going through right now. But you might be the diamond in the rough. Your policy might be the policy that doesn't have an exclusion for these types of events that we're experiencing. You want to be in touch with your insurance agent regarding what type of coverages do you presently have, what other riders are available for us to purchase, to consider to purchase. that we presently don't have. I know every year I try to call my insurance agent and say, okay, what options are available? What haven't I purchased and how much will it cost me?
Right.
What are my holes? What are my gaps in my policy?
Yeah.
And you have your standard, you have your directors and officers, you have your general liability. Hopefully you have some kind of umbrella liability, which will, piggyback off of those two policies. And then the other policy that that we've been all talking about more over the last few weeks and months, month or so, is a policy that not many communities have, the legal defense policy. And that, in very, very briefly, because I know we're out of time, but get with your agent. Whether that's a policy that is beneficial is something that you have to consider on a case-by-case approach. But the legal defense policy basically says, hey, if we have no coverage under any of these other policies, this particular policy will step in and offer us a defense. It won't necessarily cover settlement, judgment, or anything like that, but it will offer a defense where maybe the D&O or the general liability won't. And I think that ties into what we talked about earlier is, if someone wants to bring action against you for closing the amenity versus someone bringing action because you didn't close the amenity and you exposed them or others to this pandemic, or they got this pandemic, one is more likely going to be covered under your D&O general liability than the other. And I think that is important to get with your agent on, get with your counsel, and know that you've got yourself properly protected.
Excellent, guys. Well, listen, thank you very much. I just wanted to go back through the things we talked about from a summary standpoint. I don't think we'll have time to go through a Q&A. You will get a survey, and if you thought this dialogue was helpful, you think you'd like us to continue it, please answer the survey, and perhaps we'll circle back. From a closing of amenities standpoint, most are closed now. I think the guidance that you received this afternoon was, if you closed your amenities without the guidance of your counsel, get with them to dot your I's and cross your T's. With respect to positive tests, Castle's got its playbook available, which you're welcome to have if you email us at info@castlegroup.com, which is up here. But have a plan and communicate that plan. And again, even in advance, your likelihood of getting a positive test in your community is probably high. Get with your attorney, have a plan to communicate. Quarantine enforcements, really call the health department. Not your job as a board member to enforce quarantine and all of those types of things. From a guest visitor standpoint, again, you have lots of flexibility in this time. Get with your attorney, adopt the policy, make sure you tell everybody. I think we're really at the point now where if you were limiting guests a month ago, you probably have more flack than you get today, given what's going on in the world, I would say. From an association continuity standpoint, collect your April maintenance. Everybody's watching very closely. Their April 15th, which is that 15-day grace period. Where are we going to stand? Look at your cash resources, talk to your professionals about what might be available to you, and think about going to your banking partner. And then from a risk mitigation standpoint, you are protected by the indemnification in your documents, the reasonable judgment rule, and then we have that blanket, get with your insurance company and make sure you're properly covered. So with that, guys, I wanted to thank you very much for your time this afternoon. Thanks for pinch hitting when the technology messed up a little bit, but we appreciate your time. And everybody who's listening, thank you very much. And we'll hope to see you again soon.
Thank you.
Okay. Thanks, everybody.
Be well, everybody. Stay safe.
Bye-bye.